right, one of the records cases, Terrorism versus Christopher Ruff, 2021-043-799, 2021-048-968, 2021-063-564, 2021-071-040. Mr. Hawkins is here for the state. Mr. Ruff, can you give me your name and date of birth?
Christopher Dane Ruff.
Just a preliminary matter or a couple before we get into your cases, Mr. Ruff. Mr. Ruff, I know that it is always your intention to record the proceedings when you come into court. For the most part, we've always allowed you to do that. However, if you look at the rule, and I know that you're aware of the rule, Mr. Ruff, anytime there is a personal recording device, or what the rule refers to as a recording device, and then there's a personal audio recorder. Anytime somebody wants to record a hearing pursuant to 122, if there's any photography or photos taken, those requests need to be made in writing to the court. Obviously, that's never happened in this case. There is only one exception, and that's under 122H. And under 122H, it says a person may use a personal recorder during the proceeding when the person is notified the judge or the judge's staff prior to using the device. A personal audio recorder is a device used to record audio only. So the rule is clear. The rule is also clear under Rule 122K. Subsection 1, there's no use of recording devices while the judge is off the bench. A person may use a recording device in a courtroom only when the judge is on the bench, and use of a recording device must terminate when the judge leaves the bench, except as provided in paragraph I. More specifically, under Rule 122.1, it says recordings outside a courtroom. First of all, you can only record photographs or videos if it's been specifically approved by the court under Rule 122, which means it must be in writing prior to the hearing. Under 122.1C2, talks about recording or photographing somebody outside the courtroom. It says in areas of a courthouse other than courtrooms, no one may photograph or record an individual without that individual's express consent. Mr. Ruff, it's been brought to my attention that while you were in the Mason City Courthouse, you personally recorded a conversation with an attorney. You yourself did. You videotaped that person against that person's will or knowledge. You did not let them know that you were doing so. You knowingly and intentionally violated this rule, even though you know the rule. You did so. So for that reason, Mr. Ruff, you are no longer permitted to record under section 122. Okay, so I'm asking you to shut off your recording device.
What recording device are you talking about?
Mr. Ruff, I'm not asking you to tell me which recording device. I'm just saying you're not allowed to record. So if you have a recording device on.
Why are you so worried about being recorded?
Okay, Mr. Ruff, you're not going to do this today.
Do what? I'm asking
Mr.
you a
Ruff,
question.
Mr. Ruff, not today.
I don't get to speak.
Mr. Ruff, don't push me today, please. If you have a recording device on, you need to shut it off. The rule is clear for anybody else in the courtroom. We need to receive a request or notice. The court has not received any notice from anybody regarding personal recordings. That's what the rule calls for. So I'm directing any of you who are recording, please shut your recording devices off pursuant to the rule. If you are recording pursuant to the rule, since there's been no request or notice made to the court or by staff, I checked with my staff before I took the bench. So I'm asking you all to please do that. If you're caught recording, you will be asked to leave the courthouse. All right. Mr. Ruff, let me go ahead and address just some of your motions because there were some notices and I don't want to not address them since you did file them. notice to the court which was filed on, looks like June 6th. There was a motion, Mr. Ruff, that you had filed emergency procedural motion to refer to the Superior Court, trial de novo, inspection of record, emergency stay of proceedings, request for court appointed counsel. I guess you were filing that under Rule 8 of the Superior Court Rules of Criminal Appellate Procedure, so this is something that is intended for the Superior Court to address. But let me go ahead and just address your notice to the court. I know, Mr. Ruff, that you had indicated in your notice that you had never received a proper record to do the appeal. So what I wanted to do, Mr. Ruff, was just briefly go over, because I wanted to look over your cases and just make a record so that it is clear. In the 4 cases, Mr. Ruff, where you were found guilty and sentenced, you had, in 3 of the cases initially, and I'll reference those cases. There was case 2021-071040 and case 2021-048968 and 2021-043799. There was a court-appointed attorney appointed in that case in December of 2021. That lawyer had filed a motion to withdraw. Then you had retained the services of a private firm by the name of Mays Tellis. They had filed a notice of appearance in January. And they were representing you in all 4 of the cases. On the 3 that went to trial on May 26th of 2022, in fact, 2, you didn't have 1 attorney, you actually had 2 private attorneys here from that firm representing you. And what I wanted to make clear for the record, Mr. Ruff, is in these cases, there were no pretrial motions, there were no evidentiary hearings, there were no oral arguments on any motions, because no motions had been filed. The only motion that had been filed in any of those 3 cases, there was 1 motion for a deposition of an officer when the interview had not been conducted. However, that motion was deemed moot by your counsel because the interview later took place. So just for the record, there were no pretrial motions, there were no evidentiary hearings. And so the only issue was the trial. The trial took place on May 26th in those 3 cases. You had private counsel. Like I said, you actually had 2 attorneys. That firm had filed a motion to withdraw then after those trials due to irreconcilable differences with you, Mr. Ruff. And then after the sentencing, they were allowed to withdraw. The other case, which was set for trial in August, again, you did have the Mays Tellis firm. However, their request to withdraw was granted, and then you represented yourself in that matter. But prior to that time, there had been no contested motions. There had been no evidentiary hearings. There had been no oral arguments on anything pre-trial. So the only thing, Mr. Ruff, that was going to be appealed in this matter was obviously what occurred during trial, or what you may have disagreed with during trial, and what you may have disagreed with in terms of the sentence that you received. And according to your notice to the court, Mr. Ruff, I noticed that you simply referred to Rule 7C regarding items that you believe that you didn't have to do your appeal. However, you had everything to do your appeal. 7C refers to items that the clerk then has to transmit to the Superior Court once the appeal is perfected. The appeal is perfected, Mr. Ruff, once a memorandum is properly filed. Then the clerk merely sends those. So let me go over those items. Those items are a notice of appeal, Mr. Ruff, which you had because you're the one who filed the notice of appeal, so you obviously had your own notice that you filed. There's what's called a docket or list of events, and that's just where the clerk merely prints out the list of things that occurred. That's under C2. There's a documentation of record of payment. So if there's any fines, restitution, or bond that you had paid, that's simply they send notice that you paid those. However, there was no bond in any of your cases. No fine had been paid, nor was there any restitution paid. It says that the charging document has to be sent to the court. Obviously, you and your attorney from day one always had the charging documents. You knew what you were charged with. You had the complaints. You've always had those matters. Under item 5, it says disposition or judgment or sentence. Obviously, Mr. Ruff, when you were sentenced, there was that matter was recorded. There was a transcript of those proceedings. Also, you received the judgment and sentence. You were given that the day that you were sentenced, so you had that item as well. And then it says 6, the order or judgment or ruling that is the subject of the appeal. The ruling or subject of the appeal would have been your sentence that I imposed, which you had fully, and the transcript, as well as the trial transcripts. You had those items. Item 7, any written motions, responses, or replies. We've already gone through that. There were no contested pretrial motions. There were no contested pretrial issues in your case. There were none filed by you. There were none filed by your defense counsel, including your private defense attorneys, that private firm that you had retained. Any exhibits, which obviously the parties had. And then it says the recordings or certified transcripts of the trial and the sentencing order, which you had. And the last, if designated for inclusion by a party, oral argument on motions, voluntariness, suppression hearings, aggravated or mitigation hearings. Again, most of those things just did not occur in your case. Those things were absent. So you had all the documents, Mr. Ruff. You had more time than most individuals in this entire city of Mesa are ever afforded to do an appeal. Judge Tatz denied your motion for stay. Judge Tatz found that you abandoned your appeal because he gave you yet another extension of time. And since you did not file that memorandum, he felt that your appeal was abandoned. So the only thing I can do this afternoon, the only thing legally I can do, is to reimpose sentence. I have nothing else that I can do at this time. So I just wanted to make the record clear for that. And I did notice, Mr. Ruff, that...
So do I get to speak now and make the record clear for my behalf too?
Mr. Ruff, I'm gonna go through this and then...
And then I don't get to speak later?
Okay, Mr. Ruff, let me just finish this. Not that close back, no. Mr. Ruff, in the motion that you filed, or the emergency procedural motion, where you have a request and a reference for many things under 8C.
That's like a new rule that goes to the Superior Court.
Mr. Ruff, I understand that, sir.
And it freezes this.
Okay,
case.
Mr. Ruff, let me finish, Mr. Ruff. It says under Rule 8C1, procedural motions are motions that may determine, 1, whether the appeal should go forward. Procedural motions include motions to dismiss where there is no right to an appeal. That doesn't apply. Appeals from guilty pleas, you didn't plead guilty. Appeals that are not timely filed, you timely filed your appeal. And motions to dismiss or motions to strike. Procedural motions may be made at any time after the filing of the notice of appeal when set forth therein. So they specifically say what issues apply to those motions. Again, that's going to be for the Superior Court, but the request you made clearly fall outside this rule regarding that issue.
What request is that?
And so the only thing I can do, Mr. Ruff, today, the only thing I can do legally as this court is to, since Judge Tatz found that you abandoned your appeals, the only thing I can do is I have to reimpose sentence by law. There's nothing else legally that I can do. So, Mr. Ruff, if you want to address that, you can.
I filed a procedural motion. In the rules, everything that happens in this court is frozen until the Superior Court makes a decision on the procedural motion. Yes, it is. Still reading.
Okay, I'm going to respectfully disagree with
So
you.
you just disagreed on what the rules say and what
No,
they are.
Mr. Ruff, you were found to have abandoned your appeal. There is no appeal pending. You filed the special action. The Superior Court denied your special action.
One of them.
I understand, Mr. Ruff. So at this point, there's no stay in this court. There's been no request for a stay. There's been no stay ordered by the Superior Court or a higher court. The only thing I can do now is reimpose. Anything else you want to tell me?
So you say that I don't need any of the things in 7C, that doesn't apply to me. Rule 8, on how you write the memorandum, you're supposed to write it with reference to the record. The record is defined in the previous rule, Rule 7C. A list of events is every time that I've had to come into court. If I need the transcript from one of those events from the time that we were in court where you admitted to watching my YouTube channel and I want to appeal based on that, I need the transcripts from that, which means I need a list of events so I can get the transcripts to base my appeal on that. Why would you send 7C to the Superior Court without giving it to me and then send them my memorandum? They haven't been watching this case. They need to be able to reference the record to make sure that my memorandum was written correctly. That means I need all the information from Rule 7C. You guys have misinterpreted the rules. I'm not done talking. Do I have a right to be heard?
Okay.
Do I have a right to be heard? I'm trying to be heard right
Okay,
now.
Mr. Roth?
I guess not. Okay.
Right. I just went through 7C,
And you misinterpreted it again, right?
item by item. That's your opinion, Mr. Roth.
Not as the law, but
Okay,
whatever.
anything else you want to say, Mr. Roth?
Not to me. I object to everything that you're doing.
Right.
I object to your
We got-
unlawfulness, your constitutional violations.
Case number 2021-043-799 pursuant to the finding of the court, the finding of entering a judgment of guilt previously for the offense of criminal trespass as a class 3 misdemeanor. You were found guilty in that case. The court imposed 5 days of jail. Court's reimposing that same jail time.
What about all the time I did in jail when I was arrested?
That's straight time, no 2 for 1. That jail is concurrent with docket number 2021-063-564.
What about all the time I was spent in jail when I was arrested for these cases? Does that just go away? Nobody counts that?
Mr. Ruff, that's my ruling, that you're gonna do 5 days, okay, sir? That was my ruling previously. I'm
What about all
reimposing
the time
that.
I did in jail already?
Mr. Ruff, I'm giving
It's
you
been
5
days
days
in
to get
jail.
to serve. In the case of 2021-071-040 pursuant to the finding of guilt in that case and your previously imposed sentence as to count 1, the disorderly conduct, 3 years of probation, 180 days of jail. All 180 days are suspended. As to count 2, the trespassing charge, you were found guilty of that as well, for that offense. You were placed on 12 months probation with 30 days suspended jail upon completion of counseling and probation. The court did order counseling in that case. The court ordered that you contact Prodigy Healthcare within 2 business days to get set up on that screening and counseling for anger management. We will give you that directive. As a term and condition of your probation, you shall not go to the areas where the Mesa Police Department are conducting an investigation. You shall not report any members of the Mesa Police Department while you are on probation, sir. In the case of 2021-063-564, pursuant to you being found guilty in that matter, to the charge of criminal trespass as a class 3 misdemeanor. You're placed on 12 months of probation, 5 days in jail. While you're on probation, you are not to return to Mesa City Plaza. Those 5 days in jail will be concurrent with the jail time of 2021-043-799. The last case, case number 2021-048-968. You were found guilty of failing to obey a police officer. You're given 24 months of probation, 90 days jail. All 90 days are suspended. Counseling was ordered in that case, sir. Again, you were directed to contact Prodigy Healthcare within 2 business days to get set up on that screening and counseling for anger management. And in that case as well, I did note that you shall not go to the areas where the Mesa Police Department are conducting an investigation. You shall not report any members of the Mesa Police Department while you are on probation, sir. Mr. Roth, I will have my clerk come in a minute. They will provide you with those sentencing documents. Mr. Roth, regarding your 5 days of jail, sir, I'm going to give you up to 30 days for you to pick a date that you would self-surrender. Do you have a date in mind, Mr. Ruff?
No, 30 days from now,
You have up to 30 days.
and mark it on the 30th day. But I object to going to jail with the sentencing and everything that you're saying. It's erroneous, illegal, and unlawful.
All right, Mr. Ruff, what time do you want to go in? I'll give you up until July 21st. What time do you want to go in on the 21st?
Midnight.
I'm not gonna have you go in at midnight, sir. I don't want there to be any conflicts. You go in between, how do you go in between 8 a.m. and 4 p.m.? What time do you want to go in between 8 a.m. and 4 p.m.?
I think 8 a.m. because I'll be cop watching the night before. I'll need to sleep the rest of the day.
Let me self-surrender on July 21st. At 8 a.m. Mr. Hawkins, I didn't mean to ignore you, sir. Did you have anything that you wish to add?
No.
All right, Mr. Rupp, just hold tight while my clerk come on in, and we'll get you those necessary documents. Beatrice, if you could come on in and give Mr. Rupp the sentencing documents, thank you.
We'll be taking both of you to federal court and I'm sure that personally. Both of you are going to be sitting in federal court and answering for what you do. I think it's funny. I really do. I think it's funny. Watch.
You done, Judge?
We're done.
Federal court. What you're doing is illegal. You took an oath to the Constitution. Just remember that. It's a crime to violate your oath. I told you that before. I've been talking about it for years. But you want to follow through with this, I'm going to take you to federal court. I'm already talking to the FBI about you. DOJ. I've made friends recently. And for your crimes against the American citizens. You being one of them. You're a criminal. You're really a criminal, I'm not. I brought my son so he could witness your terrorism today. You wanna say hi to my son over there? And my other baby brewing in the belly next to him? Americans have died for the freedoms that you're willy-nilly slapping around right now. My family members have died defending American freedoms, and you're up there shitting on them.
The worksheets are completed, please, without multiple cases, you can print them out.
about 5 more minutes until I do.
Yes, sir. 2 days ago.
This is like part of the process. I think we have to know how to bring some paper. I guess.
The judge is tired.
He left the bench. Case dismissed.
Yeah.
Definition of kangaroo. So the judge on fire. You should have already had all that stuff. You know what the rule says? They're supposed to provide it. You heard it. You had trial. Your attorney should have given you that. Why is it in the rule 17? See, what they don't want me to be able to do is bring up the other times that I came into court, get the transcripts from those court dates, and be able to appeal things that happened in prior court dates. Not all about these motions and things. Well, this file. Other shit's happened since I got arrested. This was 2 years ago. 2 years ago. I've been to a lot of court dates since then, where a lot of appealable issues could have came up. But then we get into, well, we don't have those records anymore. Now we gotta do a trial de novo. I don't. You contained right here in this little Nazi shit.
Cool.
Isn't that right? You've got about 30 seconds. All right, well, okay, you guys, FYI. I'm leaving. I don't know if you guys are hanging out.
Yeah, I need help with the back.
Nazis didn't do so well. I'm gonna go out to the parking lot with my car and smoke a cigarette. See how much of a joke that is? Hope you enjoyed it. Make a big deal about reporting. You did it against somebody's will. I was waiting for the, okay, so what are you threatening me with? Nothing, because it ain't illegal. That's why I do it. That's why this court date's going on the internet.
Judge walked out first. You walked court's over. You're done.
Yeah, you got off the bench, that's it.
And then just trying to take away your right again.
To record the police, dude. What the fuck? That's a constitutionally protected activity. So your rights can be suspended, you know what I mean? Where's Kelly's fat ass at? Have you ain't drunk yet?
Judge called on. Why don't you go back upstairs?
Yeah. Kiss my ass. I already fucking had my cover. Come get me, sucker.
So you would abuse your authority if I exercise my right?
Whatever. I don't personally care what you sentence me to. I'm appealing everything today, so it's going to freeze whatever you sentence me to, and we're just going to kick it to a higher court. Because clearly this one is corrupt.
They turning our communities to hot blocks. Yeah, they got Glocks, handcuffs, and badges. They swearing that they hot shots. They want to lock us and throw away the stop. Watch, you know, direct deal, show you how to cop. Watch, cop, watch. Record them when a cop stops. And ignore the pig chatter when a cop talks. You don't need a top-notch camera, just a cop watch. You gotta know your rights or you lose them. So we cop, watch.